Welcome to a special program on the Electoral College brought to you by the Robert H. Jackson Center. I am Kristan McMahon, and I have the pleasure of serving as the president of the Robert H. Jackson Center in Jamestown, New York. Our guests today are Professor Edward B. Foley, the Ebersold Chair in Constitutional Law at The Ohio State University, where he also directs its election law program. We will be using his new book, Presidential Elections and Majority Rule, as the touchstone for our discussion today, walking through how we got to the system that we have and what changes could be enacted to make it function the way the founders intended it to. His previous book is Ballot Battles, The History of Disputed Elections in the United States. Ned clerked for Chief Judge Patricia M. Wald of the U.S. Court of Appeals in D.C. and Justice Harry Blackmun of the United States Supreme Court. We're also joined today by Professor John Q. Barrett, Jackson biographer, St. John's University law professor, and the Jackson Center's Elizabeth S. Linnae scholar and board member. Ned and John, thank you so much for being with us today.
Great. Thanks for having me.
It's a pleasure.
So we're going to start this with a connection to Justice Robert H. Jackson, who conveniently provided us with some thoughts on the Electoral College. And John, I'm going to ask you to start us off with that context, please.
Sure. Well, our presidential selection system under the Constitution is, despite appearances to the contrary, not popular voting, it's elector voting through the structure of the Electoral College. And the original Constitution set that up, 1787, through the first 4 elections, if you will. And the election of 1800 produced a train wreck. And so the Constitution was amended. Thus, what we have since then under the 12th Amendment is a revised Electoral College to avoid the prospect of a tie. But electors represent the states. They're chosen in the states, and the states each choose a method by which they will appoint or select their electors. What states have done historically is use the popular vote to select electors to send to the Electoral College meeting to cast their votes, which produces a president of the United States. The Supreme Court has dealt with Electoral College related issues a couple of times. Once was just last July in a case called Chiafalo versus the state of Washington, where the court unanimously upheld the power of states to punish so-called faithless electors. Electors who, although pledged to vote for a particular party's nominee, might decide to go their own way, exercise conscience, do something quirky, etc. And Chiafalo answered a question that has been hanging unanswered for many decades. It was really teed up by a case in the 1950s when Robert Jackson was on the court. And so I want to speak just for a few minutes about Ray versus Blair. The backdrop of this case, which came from Alabama, was the 1948 election, where the Democratic Party in the state of Alabama had selected electors, expecting them to vote for the Democratic Party nominee. But once Harry Truman, the incumbent president, secured renomination as a protest against his civil rights liberalism, the Alabama electors, and frankly, most electors in the South, preferred the Dixiecrat candidate, Strom Thurmond. And so the Democratic Party, although run by progressives, not segregationists, had lost its electors months before the election occurred. To avoid that problem happening again in 1952, the Democratic Party in Alabama crafted a pledge, a promise, that if you are one of our electors, you will promise to cast your vote for the nominee of the Democratic Party. And an elector named Mr. Blair, or a would-be elector named Mr. Blair, refused to sign the pledge, refused to promise not to be a bolter, and so was denied by the party his chance to be an elector, and he filed a lawsuit. I get to be an elector, it's my right of conscience, and the Constitution doesn't allow you to boss me around with this promise not to bolt. And that case made it all the way up to the Supreme Court, where he lost. In other words, the party won. The party won its right to impose a pledge on delegates, on electors, that they would support the party's nominee. It didn't include the punishment question. That's the issue that the court decided in Chiafalo just this summer. But it included the power to compel the electors as a condition of being an elector to follow the script, to cast their vote in the Electoral College for the party's nominee. The court upheld that by a vote of 5-2. Justice Robert Jackson was one of the two dissenters, he and Justice William O. Douglas, and Jackson wrote for the two of them. The nub of his analysis is that electors, when it comes to the casting of their vote, are federal officials. They're performing a federal constitutional function, and so their right as a matter of federal constitutional law is higher than and disables any control that the state or a state conferring it on a state political party might try to exert. In the context of all of that, Jackson meditated and wrote historically about what the Electoral College had become. And he says in his customary eloquent terms, the Electoral College we have today has miscarried from what the framers intended it to be. The framers, starting with Hamilton in Federalist number 68, intended electors to be free agents, to be leading citizens, to be individuals of conscience, to cast their votes for the appropriate leader, not someone who they were scripted to follow. Jackson wrote, "No one faithful to our history can deny that the plan originally contemplated what is implicit in the Constitution's text, that electors would be free agents to exercise an independent and nonpartisan judgment as to the men best qualified for the nation's highest offices." He then said, given what's happened to the Electoral College, if it's just a rubber stamp of what party choices are, we really would be better off with a national popular vote. And so a topic that would require legislation at least, and maybe a constitutional amendment, a very contemporary topic, was also addressed by Jackson. He wrote, "The demise of the whole electoral system would not impress me as a disaster. At its best, it is a mystifying and distorting factor in presidential elections, which may resolve a popular defeat into an electoral victory. At its worst, it is open to local corruption and manipulation, once so flagrant as to threaten the stability of the country. To abolish the Electoral College and substitute direct election of the president so that every vote, wherever cast, would have an equal weight in calculating the result would seem to me a gain for simplicity and integrity of our governmental processes." Now that was 1952, and as fervent as the hope was and as clear as the alternative would be, we have not chosen that path. We have an Electoral College. We're about to select through popular vote and state certification and so forth electors who will then move forward in the process, and they will pick our next president. At this point, I'm thus delighted to recede and to hear from Ned Foley and to hear you two converse about the system we have rather than the perhaps better popular vote system that Robert Jackson would have preferred.
Thank you so much, John. So Ned, before we start into our discussion, I want to tell our audience that at any point, if they have questions, they can feel free to put them into the Q&A section for the Zoom, and we will address them. They certainly don't have to wait until the end. So please let us know what your questions are as we go along. So Ned, I think I want to start with, do you have any particular thoughts on Justice Jackson's thoughts on the Electoral College?
Sure. And I like the term of Justice Jackson's typical eloquence, because that's exactly how I feel about him. I'm so honored to be here because I am such a big fan of Justice Jackson and share my enthusiasm for him and his role in constitutional history with my students in my constitutional law class. I unabashedly tell them that my all-time favorite opinion is his majority opinion in the flag salute case, Barnett.
Yep.
To me, it's poetry. It is just the most rhetorically powerful statement of our constitutional values and our constitutional system. And, it doesn't always fit most neatly in sort of doctrinal chunks the way law professors sometimes teach classes. And it seems to me it transcends everything. And it's just so important, I think, for students as part of legal education to know that particular opinion. And if I can say one more thing about it, in addition to its own merits and just the beauty of the language, to me, the relationship between it as the majority, written by Justice Jackson, and then the dissent by Justice Frankfurter is a very good thing to teach students about how they can control their own destiny in the world, regardless of background and pedigree. I mean, Felix Frankfurter has a lot to admire in some respects. And he had the ultimate resume of being, a Harvard professor. And Justice Jackson was a self-made lawyer. And I think, and most people, I think, historically think that Justice Jackson got the better of the argument. And that's always a great lesson for students. It doesn't matter where you went to law school or where you went to college or high school. If you just are true to yourself and bring your own voice and own knowledge to the table, you can do it. And he proved it. So thank you for letting me be part of your mission and conversation.
Of course.
And happy to talk about the Electoral College as well.
Perfect. Well, let's dig in. So you start your book with a statement that the Electoral College of today is not the Electoral College that was included in the Constitution of 1787. And that seems like a great place for us to start. So what was originally intended or originally envisioned in 1787?
Yeah, and this actually surprised me when I started research for the book. I didn't really know what I would find digging into the history. And I was struck just how sharp the contrast between the original Electoral College, which was part of the first Constitution, the Philadelphia Convention in 1787. And then there's the 12th Amendment that gets ratified in 1804. It's after the debacle of 1800 that we can talk about.
Yep.
I think the easiest way to understand the difference is to think about the two presidents that the authors of each version had in mind. So the original version was built for George Washington. That's who they anticipated would win, as he did. And what they wanted in a president was a father figure, if you will, a consensus, a choice that would rise above party. It's surprising to us today, perhaps, but in Philadelphia in 1787, they thought they were designing a constitution that would prevent the formation of political parties. Now, with that, that did not work out. No. They were smart enough to know that there would be factions. They used the term factions, what we might call interest groups. So they knew there would be farmers and bankers and merchants that would have different economic interests. But they thought that separation of powers, the architecture of the system that they developed, could keep those factions fluid and in check so that they wouldn't coalesce into two permanent teams constantly at war with each other. It didn't work out, and they quickly developed this two-party competition that plagues us today. But again, the original idea was that George Washington, the president, would be above partisanship. Once it didn't work, and in the 1790s, you had the Federalist Party on the one hand, and then the Jeffersonian Party on the other. And folks who had been on the same side at the beginning cleaved. So the Federalist Papers get written by Madison and Hamilton together. Hamilton goes with the Federalist Party. Madison joins Jefferson in the Jeffersonian Party. So former friends become bitter rivals. And so when they rewrite the Electoral College in the 12th Amendment, they do so on the premise that there's going to be two-party competition. And the Jeffersonians are in power, even more so after the midterms in 1802, because Jefferson, who makes it through this mess of 1800, becomes president in 1801 and is popular. And so his party does better in the midterms, and they have the votes for a constitutional amendment, which is difficult, as we know. And so they're writing the amendment for his reelection in 1804 in mind. And it's not purely partisanship. I mean, they are one party defeating the other, but they have a vision. They say, look, if the competition is going to be between two parties, let the majority party win, right? The president, the chief magistrate, as they called it, of the whole country, should be, in a party fight, should be preferred by more rather than fewer. And so it wasn't going to be consensus anymore. Now, they were also recognizing that it was a federalist system in the sense that it was the United States of America, built from Virginia and Massachusetts in our federal system. And in fact, in 1803, when Congress wrote the 12th Amendment, sending it to the states for ratification in 1804, they were rebuilding the two twin pillars of our system: federalism on the one hand, and then what they call republicanism, or the Republican form of government, on the other. So they wanted, from their conception, a majority winner formed by having a national majority at the Electoral College out of state-based majorities. And so, different vision, and Jefferson was the idea of a proper winner under the new system.
Gotcha. Well, and then you mentioned this, and I think one of the things that struck me was how important the compound majority was to this concept. And I want to talk about that in a little bit. I want to sort of move us forward to Andrew Jackson's election, and how, although the original concept had been majority rule, we sort of now get into a system of plurality is good enough. And talk about sort of how that has changed what we now have.
No, that's exactly right. And it does require us to understand the difference between majority winners of an election versus this idea of just a plurality win. And it's very easy in conversation to kind of gloss over that distinction. For one thing, if you have genuine two-party competition and only two-party competition, there is no distinction, because by definition, whoever gets more has a majority when there are only two candidates. It's when you have three or more candidates that there's the possibility that the one with the most still has less than 50% for a three-way split or a multi-field split. And so what technically, mathematically, a plurality winner is the candidate with the most votes, whether it's a majority or not. And when the Jeffersonians were doing the 12th Amendment, they didn't have to worry about that, because they had moved from a world of no parties, essentially, to very strong two-party competition. So when they were building this idea of a compound majority, where your national majority would be based on state majorities, they didn't have to worry about this distinction between plurality and majority. They knew it was going to be us versus them, Federalists versus Jeffersonians. And so as long as Jefferson won majorities in enough states for his national majority, the system made sense. What happens with Andrew Jackson, now we're moving to 1824, and there was the breakdown of the two-party system. There was the era of so-called good feelings when the Federalist Party collapsed and you had fragmentation. And as they were trying to rebuild the system at the state level, the new rules in state law allowed for these plurality winners. And that would become the new Achilles heel, because what happened was, in the 12th Amendment, they didn't anticipate the need to write this into the Constitution. They thought they did it well enough and they would have no problem. And then suddenly a problem emerges 2 decades later, and they didn't account for it in the Constitution.
Absolutely. And so I think one of the things I appreciated about your book was that it highlights some of the significant elections where this concept really seemed to have that breakdown. As you mentioned, there are a number that you mentioned are sort of questionable, but there are 3 that you particularly point to that seem to be, the system really just didn't function as it was intended to. And the first one is 20 years after the discussion we're just having. So we're at 1848, and with Polk. And then the next one is, I think, about 40 years later, 1888, if I'm remembering correctly. And then, although it surprised me a little bit that the Bull Moose incident didn't quite factor as a complete breakdown, really the next one you come to is the 2000 election in Bush v. Gore. So why don't we start with 2000, and if you need to dip back into the history there to sort of explain some of that would be good. But since 2000 is probably fresh for most of our audience, why don't we start with that conversation?
Sure. Yeah, and these are interesting stories. I mean, I hope if people like history and are sort of fascinated by it, whether it's this book or something else, I just think in my history class, we never discuss some of the richness of detail, which I regret not knowing because it's just a fascinating part of our national heritage. But to 2000, so people may remember the name Ralph Nader. He was running as a Green Party candidate and as an environmentalist. And it's perhaps ironic or not, but because we tend to think of Al Gore, the Democratic Party nominee in 2000, as someone who was an environmentalist, but not as enough for Ralph Nader's perspective. And so we had two major party candidates. We had George W. Bush, who at the time was governor of Texas, running as the Republican. And this was at the end of Bill Clinton's presidency in 2000. And then Al Gore was Bill Clinton's vice president, running as the Democrat. And many of us remember that election for other reasons that we could talk about this year, the hanging chads and Bush versus Gore in the Supreme Court and all of the problems. And some people may remember the term the butterfly ballot in Palm Beach County, Florida, which caused a real mess. I mean, there's just a slew of stories, but none of those other problems would have mattered if the basic mathematical architecture of the system handled a third party candidate in a way that it would achieve a majority winner. Because if you have only two candidates, you'll guaranteed to get a majority winner. But Ralph Nader was a third. And most political scientists say that he was siphoning votes away from Al Gore because he was the purer environmentalist. So if your first choice was Ralph Nader, your second choice was most likely to be Gore, not Bush. There may be a few exceptions to that. But in an election where the gap between Bush and Gore was 537 votes, and Ralph Nader got tens of thousands, the breakdown of the Nader votes, if you went to any kind of runoff system, would have favored Gore by more than the 537 margin. And here's where we should talk about two different kinds of runoffs. There's an old-fashioned kind of runoff, which is just after you tally the ballots after the round one in your electoral system, if nobody has 50%, you take your top two candidates and you have a runoff. You have to get the voters to go to the polls. It's kind of expensive and it may be a hassle, but we have used this historically in various states from time to time, and some states still do this. Georgia, for example, the US Senate races in Georgia this year may go to runoffs. So we're very familiar as a society to use runoffs, and we used to use them a lot more actually in the founding era. That's why when the Jeffersonians wrote the 12th Amendment, they had seen states use runoffs, and that's why they thought majority rule wouldn't be a problem because runoffs were in place. Anyway, but if you don't like the idea of a whole second day of voting, now mathematically we can do something called instant runoff voting. It's sometimes called ranked choice voting. It's what the state of Maine has actually adopted for its presidential election for the first time this year. And what it does is it gives citizens a ballot. You have all the names of the candidates on the ballot. And instead of just picking your top choice, you get to rank them in order of preference. And depending upon the rules, sometimes they say just list your top three, or sometimes list, you have the right to rank three. If you only want to rank two, that's fine. Different ways to do it. But if Florida had used a ranked choice ballot in 2000, it's pretty clear again that the mathematical computation would have caused Gore to win Florida. And with Gore winning Florida, he would have won the overall Electoral College majority. So if your standard is this Jeffersonian principle that the winner nationally should be the candidate who gets an Electoral College majority from state-based majorities, 2000 malfunctioned from its Jeffersonian premises because the winner in Florida wasn't the genuinely Jeffersonian candidate in Florida. That was hidden by the lack of a runoff, right? Bush got this plurality, but he didn't get a majority. And if you had used a system that revealed majority preference, it would have been Gore. So then Gore would have been the majority preferred candidate in Florida, and that would have given him a national majority. So Gore was the true Jeffersonian candidate that year. And so if the system was functioning as designed, it would have produced the opposite outcome. Again, don't even have to think about a hanging chad or a butterfly ballot or anything else. So that's why I think 2000 just illustrates that the system malfunctioned according to its own philosophical premises. And this isn't a partisan point. We could look at 1992, where Ross Perot was the third party candidate. There you had the first President Bush, George H.W. Bush, running for re-election. That was when Bill Clinton was running as the challenger in 1992. And then Ross Perot was the third candidate. And the Bush family insists that Ross Perot was taking away votes from his fellow Texan, George Bush. They were both Texas business people. And so they split what was more naturally the Republican Party coalition, letting Clinton squeak through. So the way in which the system currently allows these plurality wins that are inconsistent with majority rule could sometimes hurt the Democratic candidate like Al Gore. It can sometimes hurt the Republican candidate like the first George Bush.
Yep. So I think we acknowledge, and you say this a few times in the book as well, that there is no perfect system. There's going to be an issue regardless of what system is put into place. But let's talk a little bit about what the difference is between a flawed system and a failed system.
Well, I think there's two different ways to think about that. One is, again, you're like, if we're thinking right now about what's the best system for presidential elections, I think we don't have it. I'm with Justice Jackson and think, actually, let's have a constitutional amendment and have a national popular vote and not an electoral college. I do think, though, that I want that national winner to be a majority winner. I don't want a three-way split of the entire nationwide vote that would let somebody be president with only 38% because it's the other two kind of split what would be 62%, but they really don't like. So I think you really do need and most countries that have nationwide votes, like France, for example, have mechanisms to get to a majority choice. So I think our system is flawed in that it's not as good as it could be, but you can run an election under a flawed system and get a valid result under the rules of that system, as opposed to running the election under the system and it's breaking down on its own terms. So a failed election, I would say, is one that doesn't achieve the purposes of even the flawed system. Okay,
got it. I feel like we should also do some or have some conversations about how electors are chosen. And so my recollection is there are three main ways that they're chosen. So one is they're directly appointed by the legislature. One is a district-based popular vote, which I'm guessing is largely Maine and Nebraska, since they're the ones who do the district-based voting. And then a statewide popular vote. Is that generally one of those ways is how an elector is chosen?
No, that's exactly right. Historically, those have been the three main methods. Fortunately, the first method we haven't used since the 19th century, which would be direct legislative appointment. We've decided as a society that we do want citizens to be involved in this process, even though they're involved in this indirect way, since we pick the electors. And then, as we were talking about earlier, they're supposed to just do what the party tells them to do. But within the realm of the popular vote, it could be the statewide popular vote, as we've been talking about, or it could be some form of district-based system or some form of proportional system. Maine and Nebraska use kind of a hybrid model that includes district-based as part of what they basically do is they say every state has the same number of electors as both senators and representatives. And since senators are statewide, and we've got 2 of them, we'll have 2 statewide electors. And then we have representatives that are based on districts, so we'll have our district electors as well.
Oh, gotcha. Okay.
So it's a little complicated, but it goes to the point that states can do whatever they want. And that's why one of the recommendations in my book, again, I prefer a constitutional amendment, but that's so hard to do. A second best alternative in the absence of an amendment is to utilize this power of the states to make a choice. And I think even within the notion of a statewide popular vote, they could go back to this idea of a majority winner instead of just a plurality. And using either an old-fashioned runoff or this more modern form of an instant runoff ballot, states could insist that their electoral votes are going to be based on majority rule. Each state has the power to do that today or tomorrow, next year. Again, if Florida had done that in 2000, it would have been decisive. It potentially could have made a difference in 2016 because, in all of the discussion of 2016 about the gap between the national winner, Hillary Clinton, and the Electoral College winner, Donald Trump, what I think many people overlook is the way in which President Trump achieved an Electoral College majority. He gets essentially around 300 Electoral College votes. So he's above the magic number of 270 that many people know about. That's the majority. But he only reaches a majority by accumulating electoral votes in the 6 battleground states that we're thinking about again this year. This is Florida, Arizona, North Carolina, Michigan, Wisconsin, Pennsylvania. In all of those states, which amount to about 100 electoral votes, so 1/3 of President Trump's total, absolutely essential for him to reach 270. Without those 100, he's below 270. He's less than 50% in the popular vote. Mm-hmm. So he's getting all of Florida's 29 electoral votes with less than 50% of the popular vote in Florida. So there are more ballots cast not for him than for him, and yet he's getting all the marbles from Florida. That's kind of why I wrote this book, because I said to myself, this is interesting. I knew enough about the Constitution to know that you needed a majority of electoral votes. So I said, well, how is it that we got a system today where essentially you can win in this plurality way, which is really a minority way, right? And is this consistent with original intent? Is this how the system was supposed to work? And so I went into my project not knowing what I would find, and then amazed at how clearly the evidence in the legislative history of the 12th Amendment is that they really wanted majority winners. They cared. They talked about the difference between plurality versus majority. That's right there in the congressional record. They rejected the idea of plurality winners. And yet, as you said, with the era of Andrew Jackson, we got stuck with it kind of by accident.
It's a different kind of Jacksonianness that we prefer to pretend isn't there. So we talked about, I feel like a lot of the commentary about the Electoral College, when they talk about abolishing the Electoral College, one, I think that they forget that would take a constitutional amendment in order to do that. And so that's already a fairly uphill battle, as you have mentioned a few times, to get people behind that. Now, that being said, there probably are a sufficient number of people who are frustrated with the Electoral College that just doing away with it might not be the hardest challenge. Modifying it might be the harder challenge. So in your mind, would it be better to abolish it, or does it have a place if it functioned the way it was supposed to function?
Well, I think philosophically, this depends on how much you care about the autonomy and the sovereignty of the several states. Because if you think that the United States really is, the United States of America, and that the status of Texas and California and Wyoming is absolutely fundamental to our national identity, and you want the presidential elections to reflect that, then I think you would want to keep some version of the Electoral College that has each state picking or voting for president on a state-by-state basis. You wouldn't necessarily need human being electors who are now mere functionaries and we're kind of don't know exactly what to do with them as human beings. There have been some proposals just to do away with them as people and have a mathematical formula, but still accumulate votes on a state-by-state basis. On the other hand, if you think that our nation is in a different place historically than at the time of the founding or even at the time of the Civil War, and that we really are one people, and the president should represent the entire nation, indivisible. So each American has one vote, whether you're from Texas or Wyoming or Rhode Island. Then you don't want any kind of an electoral college, because having state-based voting is antithetical to this national uniformity. So I think it's a big philosophical question. I think if you asked, the Gallup poll has done public opinion polling on this question for decades, and most Americans would prefer what Justice Jackson was advocating in that dissent, where he was saying, we've come to a time where we really just should have a national vote. And so, but the difficulty of amending the Constitution has prevented that general sentiment from becoming our constitutional law.
Yeah, I have a question from Paul that I think fits in nicely here. And he's asking whether or not the Electoral College gives smaller states or medium-sized states a stronger role or stronger impact in the election process.
A little bit, because again, the very fact that the mathematical calculation on the number of electors takes account of senators, that means there is a boost for, the small states get their 2 senators because they're Rhode Island or Wyoming, just like California and New York. But if you're really worried about that issue, you should worry about the US Senate, because the US Senate, each state has 2 senators, and there's no accounting for population difference in the political power of the states in the US Senate. Whereas in the Electoral College, it's a combination of the Senate and the House. And so the degree to which small states have a boost in the Electoral College is very small relative to the US Senate.
Got it. Okay, that makes sense. I think we should talk about, so we've mentioned a few of the potential ways to, I guess it would be correct, the Electoral College that don't involve a constitutional amendment. So we've talked about the state ranked choice voting, and we've talked about a national popular vote. There's also the national ranked choice voting option, I guess, which is kind of a hybrid of the national popular vote and the state ranked choice. And then a 2-round system, which I found kind of interesting. So maybe round 1 happens before election day and round 2 happens on election day, since again, it's baked into the Constitution that the electors have to be chosen on election day. So there's no real way to get around that again without a constitutional amendment. You have some thoughts on the various merits of these systems, from some of our conversations, certainly what has already come up. I think I know what you might prefer, but just if you could walk us through some of those options, that would be great.
Sure. And I do have my own personal preference, but part of the thesis of the book is to say it's more important to embrace the majority rule principle and kind of get back to that idea in one way or another. So you can think of there being a menu of options that all fit within the umbrella of majority rule. And so big picture point is choose any one from this menu of majority rule options is better than the plurality system that we're currently using. So I'd rather have a consensus around the idea of majority rule first, and then let's decide which version of majority rule do we really want. So I do think there are pros and cons of the different versions. The 2-round system in some ways would probably be least intrusive to what we have now, because if most Americans basically think on November 3rd this year, or really any year, they're choosing between two alternatives, the red team and the blue team, right? On the debate stage, there's two candidates usually, right? We do think that we have a two-party system. So if we want the system to actually perform rationally with those expectations, one way to do that is to have a kind of preliminary vote around Labor Day that would allow your extra parties, your minor party candidates, to have a shot at winning. So they have a fair chance, the Libertarians, the Green parties, the Reform Party, whoever. And if, for whatever reason, one of them got momentum and became one of the top two finalists, then they would move on to the general election. You mentioned 1912, the Bull Moose year. That is an interesting and important year. And because that was when Teddy Roosevelt, this was after Teddy Roosevelt was president, and President Taft was his successor, Republican, and Roosevelt had been a Republican, but he didn't like what Taft was doing. So first he tried to fight for the nomination, but the Republicans stuck with Taft. So then Roosevelt bolts his own party and forms a third party, the Bull Moose Party. And so there's a three-way race between Roosevelt, Taft, and Woodrow Wilson. And Wilson squeaks through because essentially the Republican Party splits. It's a little bit like Ross Perot and George Bush again. But if you had had this two-round system, the incumbent Taft actually would have come in third in round one, and the runoff would have been between Wilson and Roosevelt, the upstart. It's hard to call a former president as the upstart, but in that context, he sort of is. And most political scientists and historians think Roosevelt would have beaten Wilson straight up, but he gets boxed out by the plurality complicated. Wilson gets the plurality, defeating the true majority preference probably of Roosevelt that year.
Yeah. So I think one of the things we haven't addressed yet with regard to majority rule is, why does it have to be a winner take all kind of system in a plurality? So let me rephrase that question. So in a plurality, why does it have to be a winner take all result? Why couldn't it be an apportionment in terms of, if you get 38% of the vote, you get 38%, assuming that, whatever the rounding needs to be to get you to a whole number of people, part of that state's electoral votes. Why does that not seem to have found favor with the states as a general rule, that as a great path forward?
Yeah, so states absolutely could do that in a way. As you mentioned, Nebraska and Maine have a little bit of a version of that. I think the simplest math for me to do is to pick a state that has 10 electoral votes. Some states do. I think Minnesota might, but I know there's some. And so you can imagine a race where one candidate gets roughly 40%, another candidate gets roughly 40%, and the third candidate gets 20%. And that would be really easy. 4 electoral votes for one, 4 electoral votes for the other, 2 for the third. Totally constitutional. States could do that. The reason why states don't is this competitive pressure to have clout. Imagine this, particularly the big states, so if a big state like New York or California did that, they would lose the muscle of plopping, 50 electoral votes on one side or the other, or 40 or whatever number it is. And states like clout, we saw this at the beginning of the country, as the states were experimenting what to do. Virginia, some of the bigger states, quickly gravitated to the idea, let's not divide. Let's put all of our electoral votes, winner take all, behind our preferred candidate. Now, again, the original version of that was the majority preferred candidate within the state. And that, again, we could go back to that. So I do think, so consistent with that competitive pressure among states, if California really wants to put all of its eggs in one basket, majority rule allows that. And I would think California would rather put all of its eggs in the basket of who its citizens genuinely prefer than all of the eggs in the basket of the one that they don't really want. That's why, we've got this schizophrenia, I think, if that's appropriate to use that term. I mean, we think we have a two-party system, but we actually function not completely consistently with that. So in a way, we have the worst of both worlds. There's a complete disconnect between the goals of the system and operationally what it does. And part of the book is to try to just bring the actual system in alignment with its own goals and expectations.
We have a question from Chris about how we can avoid the gerrymandering of the Electoral College in the future. Is it something the Supreme Court should be weighing in on? Is it something that, from a grassroots perspective, it needs to come from the people, and we need to be telling our state legislatures and our Congress people, this is how we think the system should function?
So I think, when the dust settles on this year's election, whenever that may be, and we think about the future, I think we're going to have to think about electoral reform and enhancing our democracy, small d democracy, without as much reliance on the Supreme Court as we've done the last half century. I actually think the progressive era is a model. My next book is going to be about electoral reform in the progressive era, because it wasn't perfect by any means. On the issue of race, the progressive era was not very progressive, unfortunately, but it was an era that gave us the election of US senators, which used to be appointed by state legislatures. We got women's suffrage during the progressive era, so we did get expansion of the franchise in that respect. We got first campaign finance reforms. There was a lot. We got the secret ballot. It was a fertile era of electoral reform, but none of those reforms came from judicial decrees. They were all either constitutional amendments at the national level, or state constitutional amendments, or statutes. Where we are in history today, we have been the beneficiaries of reform given to us by the Supreme Court in the Warren Court era. One person, one vote in the 1960s, Reynolds versus Sims is the case, a whole set of precedents. And that era seemed, I'm a fan of that jurisprudence, but I think honesty requires acknowledgement that the ascendant philosophy on the US Supreme Court right now is original intent and text-based interpretation. And the Warren Court precedents that gave us doctrines like one person, one vote were not originalist in jurisprudence. They were not, because the Constitution as written has only discrete rules about voting. Yes, the 15th Amendment says no racial discrimination in voting. Yes, the 19th Amendment does give us women's suffrage, but there is no general constitutional right to vote. And so if we want to think about, and so to the point about gerrymandering, there was a case on the actual gerrymandering of congressional districts coming out of North Carolina a year or so ago. And the claims that the plaintiffs made were built on those Warren Court precedents, saying if we're true to the notion of equality of voting rights, you wouldn't allow gerrymandering. And the current Supreme Court said, we're going to revert back. We talked before about Felix Frankfurter. Felix Frankfurter wrote, keep the court out of the political thicket. Don't let courts get involved in politics, so-called political question doctrine. Well, the Chief Justice Roberts, on behalf of the 5-member majority in a case called Rucho versus Common Cause out of North Carolina, invoked that Frankfurter idea to disallow a constitutional claim that was predicated on these Warren Court precedents. So we're going through a transformation in jurisprudence that will be with us, I think, for a while, and I think will require electoral reform to come from we the people through ballot initiatives, referendum, constitutional amendments, statutes, not so much through the courts.
We have a question from Ira, since we're on the topic of the Constitution, of is there anything in the Constitution that might allow for the Electoral College to compromise how it operates?
That's an interesting question. Well, this whole notion of independent thinking on the part of the electors that we were talking about at the beginning of the hour, the Supreme Court's newest decision is antithetical to that. Now, it's a little tricky because the Supreme Court said states have the right to make sure that electors are true to their pledge, even to the point of kicking them out of the Electoral College if they violate their pledge. So it's a very stringent test that way. But it empowers the states to do that. It doesn't require the states to do that. So we actually still have a world where there is a chance that electors could act independently, not in every state, because about 15 states have the kind of rule that the US Supreme Court just approved. But in other states, electors can go their own way. So if that's the concept of the compromise that the question is thinking about, it's at least a theoretical possibility still. I don't think as a practical matter it's likely to happen, because I do think the parties are pretty good about enforcing their pledges even without the backing of state law. If the concept of compromise is having state laws adopted that work within the Electoral College framework to kind of ameliorate some of its problems, that I definitely think we can do. Whether you like this ranked choice voting idea or you like the proportional representation idea, I think there is room for fertile creativity that could be thought of as the spirit of compromise.
We have getting a few questions about the upcoming election, which I'm going to get to in a moment. Just to stay within some of this context first, how might you foresee a presidential election or a presidential campaign, I guess, functioning if the Electoral College didn't exist? Would candidates tend to focus, and this is a question from Rod, would candidates tend to focus on the highly populated areas as a result? And so that would then remove some of this voice that the smaller or medium-sized states have?
It's a really important question. I wish I were a political scientist as opposed to a lawyer, because I think that might give me some better insight. But, my instinct is that campaigns would adjust and would be creative. It would mean, I think, that candidates would look for pockets of votes in ways that might surprise us, at least initially. If you follow politics closely, even in the battleground states right now, like I'm thinking about Pennsylvania, I've heard how, Vice President Biden, for example, is thinking about not winning rural counties in Pennsylvania, but just by winning enough there, because again, every vote in Pennsylvania counts. He knows he's going to win Philadelphia and a big city, but he has to up his margins there, but try to reduce his defeats elsewhere. So, and likewise, we've seen President Trump, he's not going to win the African-American vote, but there's been some news stories the last couple of weeks about moves that he's made to try to at least reduce his losses within that community. And if that concept was played out on a national stage, we might see candidates campaigning for votes in ways that might surprise us, because they wouldn't necessarily be campaigning in every place to win, but they might be campaigning in some places to reduce their losses in those particular localities. So, hard to predict, but I do think it would have to be campaigns that acknowledge the fact that every vote had counted equally, whether it was in Los Angeles, a major media market, or it was in Arkansas or wherever, because every vote's the same. And that fact would, I think, ultimately propel the candidates to make whatever decisions they made.
Okay. We do have a couple of questions from Jason and Jerome about the Interstate Compact. And do you think it is likely that enough states will adopt or sign on to that compact, that it will actually be activated? And maybe give us a brief understanding of what the compact is before you get to that.
Sure. So this was an idea first surfaced after 2000, and we've talked about that. And that was an election where, again, Al Gore won the national popular vote, but didn't win Florida for reasons we talked about. And so this is a really creative idea. Whether it's constitutional or not is another question, but I give credit to the people who thought about it. Again, the magic number is 270. If you win 270 electoral votes, that's the presidency. So the idea is that if enough states can amass their own electoral votes in this compact idea to reach 270, they can control the outcome. So rather than appointing electors based on their own popular vote within each state, what if they promise that they will simply award their electors based on the overall national popular vote? So that would be using the mechanics of the Electoral College to kind of defeat the Electoral College. And saying it that way is precisely why I'm worried that it might be unconstitutional, because I could imagine the court saying, nice try, but since you're trying to defeat the whole purpose of the Electoral College, we're not going to let you do that. But but the other point is it going to happen? Again, it's been around now for 20 years and it hasn't taken effect. A number of states have signed on, but not enough. I think they're still about 70 votes short of the magic number of 270, roughly. It did pick up some momentum after 2016, because again, given the angst that many people have felt after 2016 and the gap between the national vote and the Electoral College, some more states signed on, but still not enough. So my thought on this is that if we have another mismatch between the Electoral College and the national popular vote, there will be more momentum for this idea. I still don't know that you're going to get to the magic number, because by definition, it means that purple states, because to get to 270, you got to get to some of those battleground tipping states. And then they may think, well, wait a second, do we really want to, because basically the state that signs on is saying it's no longer our state, because being in the compact means you're willing to disregard your own state's preferences in favor of the national preference. And that may be hard for state legislatures to do. Final thought goes back to this distinction between plurality and majority. The compact would only allow for a plurality winner, because we don't have the mechanism to have a national winner that's a majority winner. So the compact could give us a three-way split. And some viewers may remember earlier this year, the CEO of Starbucks, I think his name Howard Schultz, was thinking about running as an independent. And when he did, the Democratic Party had a collective freakout under the current system, because they were afraid that he was going to be anti-Trump, but he's going to be an anti-Trump alternative to whoever the Democratic Party nominee was. So the fear was that he and the Democrats would split the anti-Trump majority, allowing Trump to win based on a plurality, which can happen under our current system on a state-by-state basis. But if you adopted the national popular vote compact, you'd be replicating that exact same problem just on the nationwide level. Because if you had a three-way split and two anti-Trump candidates split the majority, Trump would win the national plurality and win on that basis. So that's why I think if we do go to a national vote, we should make sure it's a majority vote.
Great. All right, so let's turn to just shy of 2 weeks from today. What should we anticipate that election night 2020 will look like?
We should be ready for lots of different possibilities. The key here is to be flexible and nimble and roll with the punches, so to speak, because it could. I can envision a couple of different scenarios. One scenario is if Vice President Biden really is winning decisively in some of the states that have preliminary counts early on in the process. Florida has been signaled as an example of this. It may look relatively early like it's going to be a very good night for Vice President Biden, even not knowing the result in a state like Pennsylvania, which can't have a preliminary count as nearly as quickly. Even under that scenario, anything that we know on election night is still unofficial, right? We never get official results until we get certification of the popular vote. And then, of course, the Electoral College has to meet on December 14. So even what looks like a good night for a candidate is still just projection, still just tentative. And what I've said to a couple of folks who, again, trying to prepare in this way, what's given us closure in the past before official results has not been so much the network's projections, where, the Walter Cronkite saying, we, CBS News, say so-and-so wins Pennsylvania or whatever. What's given closure is a candidate's willingness to concede defeat based on those network projections in advance of official results, right? Because the networks can't do anything other than say what they think. And so I can at least imagine a scenario where the networks are confident in their projection, but if there's no concession speech, we still have to wait for the official results to be certified to get an actual answer. So as you're preparing for election night, prepare for what the networks tell you and be sophisticated about that. Remember, they can't declare winners. They have no official role. They can only help guide you to think what might happen. But the key thing to look for is what do the politicians say? The two candidates themselves, the two main candidates, and then their political allies in Congress, because that's going to tell us whether we have a fight on our hands in terms of something that would look like Bush versus Gore in an effort to try to use litigation to reach a result, or we're not going to have a fight on our hands and that there's going to be an acceptance of the tally. That's going to come from the politicians themselves.
We just had a question from John as well of, is a concession binding on a candidate? And if I think back to the 2000 election, where I believe Gore at first conceded and then backed away from that concession, my inclination is that no, they're not really binding, but is there anything official that says, if you say this, I guess no takebacks within 24 hours, then it's good to go?
No, you're absolutely right. It's an unofficial part of the process. And, we really operate a two-track system. The law will ultimately control, but it's slower. And so we've developed, because of television and cable and Twitter and everything else, we want results sooner, or at least as a practical matter, what we think the results are going to be, without waiting for the official answer. And concession speeches are part of that, but they're not legally binding. So as you correctly said, Al Gore called up George Bush on election night to concede, and then when the vote tallies changed, he called him back and said, I have to retract the concession. And then he graciously, at the end of Bush versus Gore, when the Supreme Court ruled, I think the first words were, I just called, Governor Bush to congratulate him, and I promised I wouldn't call him again. So it's part of the theater and cultural norms of politics, but not the legal part.
Pam had a question as to what factors might cause the election outcome to be determined by the House of Representatives.
So the easiest way to think about that is a 269 tie in the Electoral College, right? We have 538 electors. Again, you need 270 for majority. So it is possible to get to a 269 tie. And if any of you play with those Electoral College calculators online the way I do, you can create scenarios where that's not crazy. I mean, again, if it would have to be closer than the polls suggest. But that would go to the House. So under the 12th Amendment, and this is important because there's a lot of confusion about how this process works in Congress under the 12th Amendment. There will be a meeting on January 6th of the new year. So it's the new Congress. The current vice president presides as the Senate president. And they receive the submission of electoral votes from the states. And they take the states in alphabetical order. So you start with Alabama, you have to get all the way to Wyoming. Let's assume no disputes whatsoever. At the end of that, if you get to Wyoming and then Vice President Pence announces it's 269, 269, then the 12th Amendment kicks in and the election of the president goes to the House and vice president goes to the Senate, because both are 269, 269 ties. And the rule on the House side is it takes a majority of states to elect a president. Each state's delegation to the House has a single vote. So California has one vote, Wyoming has one vote. So it's representatives in the House, but it's one vote per state. And you need 26. It's an absolute majority. So, and there could be some states that are split. Like if a state has 8 representatives and it splits 4-4, that's abstaining, but you still need 26. So this is part of why the 1800 election was such a debacle, because there was a tie between Jefferson and his running mate, Aaron Burr. And if Burr had been gracious, he would have said, oh, we know it's supposed to be Jefferson, but Aaron Burr was Aaron Burr. And so the tie went to Congress. And for a while, they couldn't get to a majority because of some split delegations. And eventually, Alexander Hamilton actually stepped in and said, I hate Jefferson's politics and morals, but at least he has morals and Burr doesn't. And that led to a duel and, 3 years later anyway. But so that's how, so it's very unlikely to go to the House, but it could. The thing to realize, there's been some public discussion about, well, if we have disputes in Pennsylvania or Wisconsin, it goes to the House. Not necessarily. Here, it's important to think about the Hayes-Tilden election of 1876. That was our most disputed presidential election in American history, way more so than Bush versus Gore. And if you review that history, you realize that did not go to the House using the procedure we were just talking about. Mm-hmm. It all got resolved during that alphabetical process of Alabama, to Wyoming. I don't know if Wyoming was a state back then, but the same alphabetical process existed. And each disputed state ended up in Hayes's column. Tilden would have loved to get the election to the House because he would have won there. He couldn't navigate the dispute there. Hayes won all of the disputes, and Hayes got a bare majority of the electoral votes and became president.
Gotcha. Okay. We do also have a question from Paul related to, has the power, maybe it's the power of Congress and the Electoral College, been skewed a little bit since the number of House members hasn't changed in a number of years. So it's not, in some people's minds, not keeping up with the population growth in certain states. Has that skewed some of the power of Congress or the power of the Electoral Colleges since the number of House members are capped?
Yeah, a little bit. I think that's true. There is some discussion that maybe an important electoral reform would be to increase the size of the House of Representatives. My own view is that should be done on the merits for what's a good House of Representatives. And I'm not an expert on that. I'm open to that idea. I think, and if that was thought to be a good idea, the Electoral College could piggyback on that, and it would again reduce to some degree this population disparity. But I think the better reform is either to try to figure out a way to just get rid of the thing completely, if we can, by constitutional amendment, or maybe try the compact idea if you like that and are willing to tolerate plurality of results in the way that worry, I don't like that, but some people are working on fancy combinations of the compact and ranked choice voting, which are very technical and we don't need to get into. But I would say, pick your method of electing a president, because that's what you think is the best way to pick a president, either best way ideally or best way practically for us now. I think piggybacking on reforming the House, let's reform the House for its own sake and keep presidential elections separate. It would be my basic instinct there.
Is there any possibility of a state legislature deciding that the popular vote can't be determined accurately? There's been a lot of conversation. Obviously, the Pennsylvania case that went to the Supreme Court just this week as to how long after you can count and things along that line. So is there a possibility that a state legislature will decide we can't know the popular vote accurately, and so we're just going to certify this number of electors in this way?
Yes, I mean, we can't rule that out. The Florida legislature thought about doing that back in 2000. They took steps down that road. They ultimately decided not to do it after Al Gore conceded. But they were prepared to take the position that it was such a close race and all these hanging chads were so problematic that, it was like a statistical tie, and they were going to assert the right to pick the slate that they preferred, which would have been a Republican slate in 2000. But then once Gore conceded defeat, they didn't need to do that. So that's the move that has been considered, at least to some degree, in Pennsylvania this year, according to this article in the Atlantic magazine that quotes some significant figures in Pennsylvania, at least contemplating that as a possibility. I think in my mind, as somebody who thinks that elections should be held for the sake of the voters, for a legislature to do that would be to admit defeat, right? Because essentially you'd be repudiating the possibility of having the voters control the outcome. This is a nonpartisan point that if you're going to allow voters to control the choice, then figure out what the voters want. And if you say you can't do that, it's self-defeating. The scenario which most worries me in this regard is not that the legislature would say, we don't like what the voters have decided and we're going to throw it out. That just seems so untenable. What worries me the most is that what if counting the votes in Pennsylvania takes too long? Because there's so many absentee ballots that they're not used to, they just run out of time because the Electoral College has to meet on December 14. And so if they don't finish counting by then, that I think would justify the legislature to step in and say, we've got to have electors. We wanted to have it based on the popular vote, but we haven't been able to count the popular vote. So here's our electors. We're just appointing them directly.
And is it because I think the electors need to be appointed by, and this was news to me, figuring out the timing of all this. So by December 8th. So is that actually what the deadline would need to be? Or could it be like, okay, we think we know some, we'll figure the rest of it out over this last 6 days, since there's that 6-day window between when the electors are supposed to be named and when they actually start their work?
Right. So these two dates are really important. December 8 comes first, and then 6 days later, December 14 is when the electors meet. The significance of the first date is that if states finish by then, Congress promises not to second guess them, what the states do when Congress meets in January. So that's why it's really advantageous to meet that deadline. It's sometimes called a safe harbor deadline, because if you get your count finished, you put yourself in that safe harbor that Congress won't repudiate the result. But if you can't finish by then, you have 6 more days to finish up, that at least you can have electors for the time the Electoral College meets. And hopefully Congress will follow what you do. It just doesn't have the promise attached.
Yep. All right, one final question. And this is actually a little bit of an international look. So if we take Israel as an example, or Germany, and this question came from Ryan, is there the potential in American politics for a coalition government? And if so, would the Constitution need to be amended to eliminate January 20th as the inauguration day if there isn't a president by then?
So, our system, mostly of the way we do legislative elections more than presidential elections, kind of forces into the dominance of two major parties. It's actually our presidential election where we see more, in other words, the Libertarian candidates, the Green Party candidates tend to have a little bit more salience in presidential elections than congressional elections. So I don't really foresee coalition governments. The one good news about the 20th Amendment is it's absolutely clear that if we, for whatever reason, we don't have an answer as to who won the presidency by noon on January 20th, the current term ends no matter what. And then there is a mechanism for an acting president. That would be unusual. We haven't had that, but at least the Constitution is clear that if everybody agrees that there's no result yet, the concept of an acting president automatically kicks in.
Interesting. All right. Well, Ned, thank you so very much for being with us today. This has been a great conversation. And I also would like to thank our audience for their very interesting questions. Really appreciate it. As I said earlier, we are less than 2 weeks from Election Day, so please vote. And early voting has started in, I believe, nearly all states. So please vote. It is important. It's important every year. So please do that. Ned, thank you so very much for your thoughts today. We really appreciate them.
Oh, thank you so much for having me. It's been an honor and a pleasure.